Lord,
Okay.
having said that, we'll also look at the reply on points of law. I leave it
Yes.
to my Lord because it's on the statute of limitation which we raised, my Lord, in our written address. And my Lord, if my Lord could recall, my Lord asked that I make copy available to the courts, the law, the
Yes.
Rivers State law. Yes, my Lord. I've been trying to see how I can send a copy to my Lord. I don't
Yes, send
know.
it to Austin
Okay,
in
my Lord.
Bayelsa.
Okay.
Austin will forward it to us.
Okay, my Lord. Yes, my
Yes.
Lord. So, my Lord, on that, we are saying that there is no outright agreement where the parties entered a written agreement before the courts or anywhere, saying that we have admitted that we are owing him any money. Under cross-examination, that was clearly raised, and the defendant actually and claimant answered that there was nothing of such. So at this point, my Lord, we are saying that the statute of limitation of Rivers State is what is applicable to this law and not the public officers law. We did not come under that law. We did not.
Okay.
We came under, yes, my Lord. My Lord, that's our adumbration. We adopt our written address,
Okay.
my Lord. So may it please, my Lord.
Thank you.
Yes, my Lord.
Eva. Yes, Eva. Unmute yourself. Unmute yourself.
Is it I?
I can't hear you. Okay. Eva.
Yes, my Lord.
Yes, go ahead.
Can you hear me now? Yes. My Lord, before the court is claimant's final written address.
Yes.
It was filed on the 24th day of April, 2024.
Yes.
In that very particular final address, we identified 3 issues.
Yes.
And we have robustly canvassed those 3 issues.
Yes.
Then on the 27th day of May 2024, the claimant also filed a reply on points of law.
Yes.
In that particular reply, we did not initially, because we filed first.
You
we
filed
did
first.
not address the issue of jurisdiction. Yes, on the 24th. So
yes.
They now having raised the issue of jurisdiction, we now address it on the reply on points of law. My Lord, yes. We adopt both processes and urge my Lord to enter judgment in favor of the claimant. My Lord, just as a matter of slight adumbration, yes. There is nowhere in the claimant's written address that the claimant admitted that that the law which the defendants are relying on applies to him. Yes. We have always maintained that the Constitution of the United States of Nigeria is supreme. It provides for permanent secretaries, and it provides for who is a political appointee and who is not. So, yes. In light of that, we believe that the Rivers State political office holders law is inapplicable to this instance. It does not guide or govern claimant's employment. The claimant was always a civil servant at the core. He was, even as a permanent secretary, he was still in the Rivers State civil service. So he never left the civil service. So at the core, claimant is a civil servant. So he cannot be treated otherwise. He must be treated according to the rules and regulations of the first defendant, which is the Rivers State Civil Service Commission. And,
Yes.
and that is the law and the regulation that governs the claimant's employment in this instance.
Yes.
The statute of limitation, which my learned friend refers to, is inapplicable. We have made such submissions in our reply on points of law.
Yes.
We cited authorities there, and the law has changed in Nigeria that limitation laws do not apply to employment or service contracts. That is the position now. So we urge my Lord to apply those law as announced by the Supreme Court, and then find that there is this case is not statute barred. But even assuming as when that River State statute applies, my Lord,
Yes.
you have to reckon with the conduct of the defendant. Of the claimant. The claimant always agitated for his right. He always made written communications to the defendants,
Yes.
informing them that he was never satisfied with the pay cut or the pay reduction. He always believed that his proper scale was that MSS2 salary scale.
Yes.
And the defendants complied, acknowledged, and started paying him the required monthly salary back in 2015 for 3 months. So that is a clear admission on the part of the defendants that the claimant was right all along. So after 3 months, they stopped paying. So preferably, the statute of limitation should now commence sometimes after November 2015, when they stopped paying paying as required under the MSSS 2 scale. So if by calculating from that to the time of the filing of this case, it will be clear that the defendant filed within time. So the River State statute of limitation is inapplicable anyway. But even if it were, the claimant filed within time. So that's our submission. And urge my Lord to enter judgment for the claimant as pleaded.
Okay. Yes, I'll give you. Yes, okay.
My Lord, I'm sorry. There is an issue.
Yes, okay. We cannot hear you.
I'm not hearing her.
Maybe we lost
Okay.
AN Otoke. Let's wait for a while and then for her to join us. Yes.
Okay.
Hello, my Lord.
Okay. Yes.
Yes, my Lord. My Lord, I'm saying that rule does not apply where the employer has left and the employer, yes, the claimant had left the service of the employee. So
Yes.
in as much as the claimant's service is not running, he has retired before he brought this action. My Lord, that law, that position of the law does not apply in this case, because he is not currently in the service of the Rivers State government. He's not in the service. He has retired before he filed this action. So that rule, that law, that decision of the court does not apply in his case. It does not, my Lord. And
it's
secondly,
right.
yes, my Lord. My Lord, and secondly, that letter he is talking about as in our admission, the claimant was then the permanent secretary of that department, that ministry, FA. Hello, my Lord.
Yes, I can hear you.
When the DFA wrote that letter, he was the permanent secretary, and the DFA was under him, under his supervision. So that letter could have been concocted. And however, the defendants have denied the fact that it was written in error. And if we move forward, no matter what, that letter cannot change, invalidate the position of the law. The position of the law still remains the same. That the claimant, yes, my Lord. My Lord, this is a humble submission, and we urge, my Lord, to dismiss the suit of the claimant.
It's all right. I will look at all your submissions and I will look at the evidence adduced, and then we'll be able to come to a conclusion. Yes, it's September 10 September, convenient to both of you for judgment?
It's convenient to me. For the
my Lord, let me look at my diary, my Lord.
Yes, 10.
20th of
September. 10. Yes.
10
my Lord, 10th of September. Okay, my Lord, it's free, but that's for now. Okay. Yes, my Lord, we take it, my Lord. We take it.
10th of September.
10th of September.
I have listened to the submissions made by both parties, each comprising both on points of law and of facts. I adopt all the processes filed by the respective parties in support of their respective arguments, and I adjourn this matter to 10th day of September 2024, God's willing, for judgment.
As the court, please.
As the court, please.
Gentlemen, thank you so much.
Thank you, my Lord.
Yes, Otueke, please send the law to Austin, the River State law to Austin.
I should also be served, please.
Yes, you said?
The claimant would also like to be served in whatever is being filed now.
Okay, she will serve you. Yes, Otueke, send it to Austin and start to Emba again. Yes.
Okay. How you doing?
Okay, I will send it to you. Thank you.
Okay. When you